Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville workers' compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. And we are back in the studio with attorney Scott Scheynost. We are going to talk about more workers' compensation issues. And today, ultimately, we're going to be focusing on reopening the claim, which may enable the injured worker to actually get more money and more benefits for that injury. Scott, welcome back to the studio.
Great to be here, Jim. Hope you're doing okay today.
I am. So let's kind of start from the beginning in terms of workers' comp. Walk us through that process, and then we'll get into this whole topic of actually reopening the claim.
Right. In Kentucky, there is a 4-year window to reopen your workers' compensation claim from the date of the settlement or the award from a judge. I think it's a unique benefit to Kentucky. Some other states may have it, but I'm not aware of any other states off the top of my head that allow you to do this. But once your case has been resolved, if within this 4-year window of opportunity your condition significantly worsens, you can get more money. You can get more money for being off work, for temporary total disability benefits. You can also get more money for an increase in your permanent impairment rating. And this is a very important function, especially for folks that have had particular types of injuries that might result in more medical treatment or a worsening of the condition down the road. It seems like it is most frequent with folks that have had knee injuries that may have had a torn ligament like an ACL tear that usually results in a fairly low impairment rate in Kentucky, 1%, 2%, 3%, something like that. Usually that's not much money. But what happens is, as we get older, if you've had a torn ACL and the doctor's gone in and done arthroscopic surgery, that surgery helps to repair the tear, but it also wakens up things that cause arthritis in the knee. And essentially what happens is that surgery accelerates the arthritis in the knee, and because the work-related injury caused the surgery, and because the surgery accelerated the knee, the cause of the arthritis, that makes the arthritis itself work-related.
Let me ask you this, for the listeners in particular. You mentioned something called an impairment rating.
Right.
What exactly is an impairment rating? Why is that important to the claim?
Right. When you have a permanent injury in Kentucky, you get money for that, and the money is based, one of the factors they base it on is an impairment rating. It's derived from a book that the American Medical Association puts out. The doctors look at this book, and they come up with a number to give you for your problem.
So they've got the patient, the worker, has gone through an independent medical exam, an IME, and then that doctor typically is the one that's going to try to assign that number?
Your treating doctor can also assign that number. That's the number we like the best from the treating doctor because they're usually considered the most trustworthy. But also if you're sent to an independent medical examination, a lot of times that doctor will also assign an impairment rating. Normally it's going to be different from the treating doctors. Insurance doctors that are companies that are send folks to people for sometimes when an insurance company sends you to a doctor for an independent medical examination, that doctor will usually be what we call conservative, and their impairment rating will be less than your treating doctors. We may have to hire our own independent medical examiner to rebut that impairment rating. So your impairment rating is important because it's a big factor that determines how much money you get in your workers' compensation claim.
And so an impairment rating may take into consideration, well, I can't lift as much as I did before the injury, I can't turn my head as much, I can't do certain things, so then I have an impairment, and the more severe that is, the higher that rating number goes. Is that kind of on point?
In general, different body parts have different ways to be rated. For instance, I think for leg injuries, there might be 10 or 12 different ways to determine an impairment rating. Loss of range of motion, loss of strength, leg length discrepancy.
Right.
One leg may become shorter or longer than the other because of the injury. Use of assistive devices, specific medical procedures, like we mentioned a second ago, ACL tears and repairs. There's a variety of different ways for the doctors to determine an impairment rating for different parts of the body. And in general, if I send you to 5 different doctors, we'll get 5 different impairment ratings for the same injury.
Very subjective.
Exactly.
Yeah.
But there's, again, a variety of ways to do it. some of these things, range of motion, you would think all the doctors would get the same range of motion measurements, but a lot of times they don't. So the impairment ratings are also different too.
So let's come back to the reopening. So you've got an impairment rating, and so you've gone through, your case is basically worsened, right? Let's say
Correct.
arthritis.
That's a criteria for it to be reopened.
Right. So arthritis is set in, or you've had a surgery that's been a complicating factor. Take us kind of from that point.
Sure. Let's say you've resolved your claim. I'm going to keep using the knee replacement as the example because that's one of the typical ways to reopen a claim. The knee's gotten worse because of arthritis. The arthritis has gotten to the point where it's going to have to be treated, and a lot of times that means you're going to get a total knee replacement or a knee replacement. And what happens when you get this knee replacement, if it is work-related, your impairment rating is usually going to drastically increase from the original ACL tear. Where the ACL tear was in the 1 to 3% range, the impairment rating for a knee replacement is anywhere from 15 to 30%. And in Kentucky, the higher you get as an impairment rating, there's a dramatically higher increase in benefits. 15% isn't just 5 times 3%, it's more like 8 or 9 times 3%, the way we do things in Kentucky. I'm not going to bore you with the details of that, but essentially what happens is once you get above 10 or 12%, you're going to have a really significant workers' comp claim. So if you're going from a torn ACL to a knee replacement, the price of poker's gone up. You're talking about a lot different amount of money. The medical treatment's a little bit different. Knee replacements also wear out too. That's some factors that you need to think in this too about your claim because they only last 10 to 15 years, depending on how they're used, and you may have to have another knee replacement down the road. But as far as a reopening, it's important to realize that you can reopen within 4 years, and if you have a significant change in your impairment rating, that's a very, very good reason to reopen the claim, and you need to investigate this as soon as possible because the way we do things in Kentucky, you only get benefits for a certain amount of time. And if you're going to reopen your claim, you want to do that as soon as possible so you can get the most benefits for the remaining period of time. If you wait, every day you wait might be a day less in benefits that you might receive. And it's important to see me or some other attorney to talk about this as soon as possible because you don't want to wait. You don't want to wait a week. You don't want to wait 6 months. You don't want to wait a year. You might be leaving literally money on the table by doing that.
Right. So, and this clock starts ticking from the date of injury, correct? Not from the date your case is wrapped up.
Correct. It starts ticking from the date of the injury. It can be extended by certain events. For instance, if you get temporary total disability benefits, that might extend the time. And there's a couple other types of events that might be thrown in there too for different disabilities. But in this, essentially, for most claims, you only get 425 weeks worth of benefits. And if you're off work for 10 weeks, that means you'll end up getting 435 weeks worth of benefits. And if you wait until after that knee replacement to come and see me or another attorney, every day you wait is probably a lot less money you're going to receive. You need to see somebody as soon as possible.
So if I've wrapped up my workers' compensation claim, and then 2 years down the road, I'm just not feeling right. My knee it's aching. I've got problems here, which could be the onset of arthritis or something to that effect. I really still only had that 4-year window total to come back and see an attorney.
Yeah, you've got benefits that are usually 425 weeks, which are 8 years, but you've only got a 4-year window to reopen to get more money. That 4 years begins to run from the date you settle your claim or get an award from a judge. So after that 4 years, you don't have a very good right to get any more money out of it. There are some interesting circumstances where you might, but in general, if you've waited longer than 4 years, you're probably not going to get much money out of this, if any at all.
Wow. So now you may have to go in for another surgery. And this is all different, however, from standard medicals, right? You want to talk about that?
Yeah.
Kind of what are the standard medicals and how does that play and why is this different?
People get reopening confused with right to medical expenses, but they're two separate rights in the state of Kentucky. As we said before, the reopening's got this 4-year window to reopen, but in Kentucky, your right to get medical expenses can last your entire lifetime. Depending on when the injury occurred, for current injuries, you may have to prove after 15 years you still need it, but if you're able to do that you still need medical treatment, you can get medical treatment for the rest of your life. And that's separate from the motion to reopen for money. So maybe you need your knee replacement 25 years down the road. That may be a cost if you continue to preserve that right that the insurance company has to pay. But as they pay for the medical treatment itself, they may not have to pay you any more money.
So an increase in benefits.
Increase in the monetary benefits, yes.
Right,
yeah.
right.
But medical treatment is separate from that.
Yeah, and I think that probably confuses a lot of people, and that's another reason to kind of get in front of an attorney and say, hey, explain this to me.
Yeah, and the legal procedure we call is a reopening, and sometimes we use that term to reopen to get medical treatment too. So it is very confusing. But the important thing to remember is that there's a 4-year window to get more money to put in your pocket. Your medical benefits may last the rest of your life. I think it's also remember the kind of situations that might be important for somebody to think about whether or not they have a claim to reopen. Again, we were talking about knee replacements. I see that a lot with knee replacements because you go from a simple surgery, ACL repair, to a very complex surgery where they're taking out joints and replacing them with artificial devices. That's why the impairment rating is so much higher. It happens a lot with back cases too. Somebody may have a simple back case and may not even have surgery, but a couple years down the road may require a disectomy, and that impairment rating might change from 8 to 12% when that happens. And if you've already had a disectomy, a lot of times,
which is basically what they're taking out the disc in between the
parts
vertebrae.
Of the disc, to relieve pressure on the spine to take pain out of your legs, maybe. But when they go in and do that surgery too, again, that causes scar tissue, and that also increases the likelihood of having another procedure down the road. So you may have had a disectomy, which is a relatively simple back procedure, but that might lead to a back fusion down the road because they've altered some of the anatomy in there, and they have to go in and actually fuse the disc together. And so your 12% impairment rating might change to 25 or 30% impairment rating, depending on what's going on.
And again, because that impairment rating has increased, chances are your benefits are going to increase if you do this properly.
If you do it within the right amount of time, correct. And again, we do this on kind of a logarithmic scale where a 25% impairment rating isn't really twice a 12% impairment rating. It might be 3 or 4 times.
Think of that old bell curve from school.
That's exactly right.
Think of the bell curve ratings. And
then another factor in all this, too, is a lot of times when people settle their original claim, they may have been able to go back to work at their old job. And in Kentucky, that's a big factor that tends to minimize how much money you get. And when you go back to work at your old job with a 1 or 2% impairment rating, we may not be talking about much money at all, just a couple dollars a week. But if you go back to work at your old job, then you can't do it because you need a knee replacement. Well, not only does your impairment rating change, but also a factor we look at that determines how much money you get, your ability to go back to work changes too. It can almost triple the other numbers in your case too. So not only does your impairment rating change, but if this reopening impacts your ability to do your old job, that can also drastically increase the amount of money you get. And sometimes just quitting your job is a reason to reopen your claim. If you settled your case at what we call the 1 multiplier, where you go to work and you go back to your same job and you're making as much money as you did before, and you're getting weekly benefits based on this, if the plant shuts down, you're not working that job anymore. If you're making less money, that money might be doubled just by the fact that you're not working there. So that's another factor that needs to be considered in this too, is your money-making capabilities and whether or not you're able to continue your job, because losing your job and job conditions, especially ones that change the amount of money you get per week, can impact the amount of money that you get out of a workers' comp claim.
And so in terms of how they get this done, or how you as an attorney begin this process, you've got to file a motion, right?
Yeah, we first of all, we really have to see what happened before.
Yeah.
Because a lot of people will settle out these rights and they don't retain them. Insurance companies like for you to waive them at the beginning so they don't have to mess with this, because they realize there's a potential for more money they're going to have to pay down the road. So first thing we have to do is look at your original settlement agreement or award to see what that says. And if the settlement agreement preserved all these rights, then the next thing we would have to do is file a motion to reopen. And this is a fairly technical procedure, and we've got to prove a couple of things, and there's attachments like medical records waivers and copies of the old case and things like that we've got to supply. But we've got to get that together and get it to the judge, and we've also got to prove a significantly worsened condition too. And sometimes that can delay a little bit the case, because we've got to get a doctor's report or some other documentation showing your condition's worsened. So workers' comp can be technical, but this is even a little bit more technical than the average workers' comp claim. I don't think I've ever seen anybody do a motion to reopen on their own. You almost have to have an attorney. A lot of people don't even realize they have a right to reopen. And if you do the motion to reopen, you have to do it in a certain format. And you can't just file motion to reopen. You have to certify that you haven't filed one within, say, the last year, things like that too. So it's a fairly technical procedure. You need to sit down and talk to an attorney about whether or not you have a claim that can be reopened, first of all. And then if it is to be reopened, then you've got to sit down and get the documents together, medical records, all the other documents we have to file together to file those with the Kentucky Department of Workers' Claims.
Again, it's easy to miss a step or forget a document. Or it'd be better to ideally, go and see an attorney and say, look, again, I need some help here. And most of the time they'll help. How do your fees come into play? If you've already handled the original case, your fees are capped, which, for the injured worker is a good thing. I mean, at some point your fees get capped, but now you're going back to reopen.
This is considered a new claim and basically it is, because we're proving another claim.
Right.
So we basically have the same caps on fees on the reopening as we do the original claim, but they're not combined. It's an entirely new fee. For instance, right now our fees are limited to $18,000 total with a lot of percentages in there. That would be the same limit on the new case. The new reopening. Right. It would also have the limit, no more than 20%, no more than $18,000, and a couple other caps inside of that.
But again, as a workers' comp attorney, you operate on a contingency fee basis. Do you want to talk about that real quickly?
Sure. Again, when we talk to folks in workers' compensation claims, we almost invariably handle these on a contingency fee basis, which means we don't charge them unless we get money for them. They don't have to pay us any out-of-pocket expenses. They're not paying us hourly. We will have to charge fees for expenses and other things we incur, for instance, doctor's reports and stuff like that. And those will be deducted out of the claim, usually after our fees computed.
And that's why in most of the ads you may see or many other conversations with attorneys, you'll always hear them say, well, court costs and expenses are the responsibility of the client. That's really what you're talking about. There are fees and expenses along the way, but the attorney typically is fronting that cost, right?
Correct.
And they'll settle up at the end after the award is made.
Correct. That's correct. But the bottom line, I guess, for most people to realize is it doesn't cost anything to call us to ask about this. It's a contingency fee. When you call me, I'm not going to put you on the clock and charge you hourly. We're going to sit down and try to figure out if you've got a case. If you do have a case, then we're going to take it on that fee, and you're not going to have to pay me till it's over with.
Right, and that's the risk to the attorney. You're deciding whether or not
that's the risk to the attorney. Yes.
You're people kind of forget that sometimes. It's like, look, the attorney has to be sure this is a good case because they're going to be fronting all of that. And a lot of times, if they don't win the case, they usually don't come back and charge the client. Correct, or at least in your case, that's
correct. And we understand people need to talk a little bit, and we're willing to give them a consultation, talk to them on the phone, look at their records, whatever documents they may have to try to figure this out. And again, I've yet to see one person that came and said, I need to reopen my case. Usually there's some other conversation. I've had clients that I've represented years before and told me something's going on now, and they never did call me. And I said, well, have you thought about reopening it? And they go, I can reopen it. Well,
they just didn't know or forgot.
We may have mentioned this to them before, but they may have forgotten.
Yeah.
But a lot of times people just don't think about that for different reasons. And I've actually had the defendant reopen cases for medical arguments where we've sat down and thought, this client is a lot worse than they were before. We need to reopen it to get them more money. And if it hadn't been for the defendant trying to save $300 on a prescription expense, I've had clients that would have walked away with thousands, literally hundreds of thousands of dollars.
Right.
If we had not reopened the claim for them. But again, because this is handled on a contingency fee, it doesn't cost you anything to call us. And a lot of attorneys handle it the same way. If you think something's going on, if the condition is not the same as it was before, if you feel like you've gotten worse, give us a call and we'll try to flesh out all these details.
Right. And Scott, what is the office phone number that someone should use if they want to pick up the phone and say, hey, Scott, I think I got an issue here and I'd like to talk to you. What's the best way for them to get in touch with you?
Our office number is 502-937-5287. 502-937-5287.
And then if you go to the website, ScheynostLaw.com, there's also a contact us form, which is real simple. You can give some information there, and then Scott will be able to follow up with you to talk with you about that. But Scheynost is SCHEYNOST law.com. And so it's fairly simple. That's a great website, by the way. You've got some of your previous settlements and verdicts and things on there.
We do, yes. And we've got a lot of free information underneath the FAQs. The hard part's being able to spell Scheynost. If you're able to accomplish that, then you should be able to get some helpful information.
Yeah.
Again, you can contact us that way, too. We have some links to some other places, too, that you might be interested in.
Yeah, and of course, there's a whole bunch of other podcast episodes that they can listen to and just kind of get some background. Get good background on what is the workers' compensation, system in Kentucky, and then, do I qualify for this? What happens if, I'm injured outside of the state of Kentucky? There's a good chance that you may be able to draw this back to, this actually is covered in Kentucky.
Right. And another thing about reopenings, getting back to them, I've reopened cases before for attorneys that have retired or no longer practicing. Just because I wasn't your attorney before doesn't mean we can't represent you in this matter. I think it's always best to go back to the attorney that you used before, but a lot of times they can't be found for different reasons, or they've decided that they don't want to practice workers' comp, or they moved to another state. But just because that attorney's moved on doesn't mean that you're out of luck. I'm happy to talk to you. Other attorneys that practice workers' compensation will be happy to talk to you, too, about it. And again, it's a free call. If your condition is worsened, like I said, there's only a 4-year window here to do something about it. You may have had your surgery, and that 4 years doesn't start till after your surgery for some reason, but it can run real fast. And the sooner you talk to somebody about it, the better your chances are, number one, of finding out if you do have a case, and number two, preserving your right to as much money as you possibly can. And another thing about these reopenings is generally when we're going from a simple injury like a torn ACL or maybe a back sprain or even a shoulder injury, a lot of the treatment has really advanced over the years. I think they were just starting to do knee replacements when I started practicing. That's how old I am.
Right.
They really just started to do shoulder replacements, it seemed like, here in the last 10 or 12 years. I'm waiting for other devices. I think I've heard that every joint in the body can be replaced.
Isn't that amazing?
Wow. I've got a back disc replacement case going on right now. So medical technology has increased over time, which means the ability to treat some of these injuries has improved. And a lot of times that improved treatment is something somebody needs to look at, and also result in an increased impairment rating. So if you've continued to get treatment, if you continue to have problems, think about this as a possibility in your claim. The exact dates for the 4 years, a lot of people don't know the exact date their settlement or award. You can find that out by calling the Department of Workers' Claims. They can look it up on the computer for you. They can give you a copy of it. Your old attorney can pull it up. We've got everything digital in our office. If we've represented you before, I can find that information out in about 30 seconds. But a lot of this stuff is out there, and I just feel like people underuse this ability to reopen the claim. I feel like I need to be shouting it out from the rooftops, especially if you've had a second surgery later on after your claim was resolved. If that's occurred, you really need to look at your claim, the award, talk to the attorney that represented you before to see if there might be more money on the table for you.
Well, I think that's where a lot of people might get confused. They think, "Hey, my benefits covered, this second surgery. I'm in like Flint. I mean, This is fantastic." But they're not thinking, "Okay, yeah, I paid for that, but actually you might be eligible for more benefits because of it."
And workers' comp is not designed to be a fun procedure, and it has all kinds of issues in it. It could be improved, but I'm not going to go into the politics of why it's not being improved.
Right.
But most people don't really enjoy going through the system. First of all, they've had an injury. It hurts them. They're worried about their condition. And that can be distasteful. At the same time, you don't want to prevent that from making sure you get what you're entitled to receive out of this.
Yeah. I mean, the process, you've always said, the process is long. It takes time. It can be complex.
Yeah.
But at the same time, it's a really good system in Kentucky compared to other states.
Compared to other states, for instance, Indiana really doesn't have an equivalent system to reopen their claims. I'm unaware of any other contiguous states to Kentucky that have such a system. A lot of other states, once you've reached maximum medical improvement, it's over. You don't get any more medical treatment. You don't get a right to reopen. But in Kentucky, you do. Even though you've got a 4-year window, you have this right. And again, a lot of these injuries that result in small impairment ratings can result in a lot bigger impairment rating down the road, depending on the kind of treatment you have, especially if there's been something replaced.
Well, and that's the thing. You might be thinking, well, okay, I can just put up with this. I can tough it out. But you may not have to, especially if you're worried about some of these other financial issues. And it could actually be to your benefit. And you deserve a good quality of life. I mean, you didn't count on getting the injury in the first place.
Yeah, and a lot of people really don't have much choice if you're not able to continue to work in your job, either because of the injury or because of other circumstances with the employer. You really don't have much choice but to reopen the claim to see if you can get additional benefits.
Well, I thought that was interesting. You said if the employer closes their doors, let's say the plant goes out of business.
Yeah,
that's a really interesting. I had never really considered that aspect of it.
One of the factors we look at in Kentucky to determine how much money you get is your ability to go back to work at your old job. And in general, if you're able to go back to work at your old job, you get less money in Kentucky. Now, in Kentucky, if you lose that job for anything other than, say, a criminal action, if you didn't steal a check from the employer and try to cash it, if the company has a plant that shuts down, if the hours of your shift change and you can't work it because you got to take care of kids, if other circumstances occur that prevents you from working that job and the circumstances weren't caused by you through an illegal act, then you also have an opportunity to reopen your claim to get more money because the financial situation has changed.
Well, I tell you, as we look at the economy right now, as we look at we're just coming off of COVID and a lot of businesses were challenged, that's a really interesting proposition is that, look, if your company is just simply no longer there and you have a legitimate claim, it may be time to have that discussion.
Yeah, we actually looked at a lot of those claims when COVID hit because a lot of plants were shut down, but what happened was some of them continued with the salary continuation, so their actual wages didn't change. But that is a consideration. The economy is different than it used to be. People are working in different spots and doing different things, and your ability to work is one of the factors we look at, not just the impairment rating. So if you've lost your job, if the company shut down, if the number of hours you've worked are less and you're making less money, that's a factor that we have to look at too. We have to look at the original claim to see how the money was based on. But if you're getting weekly benefits and those weekly benefits are based on you going back to work at your old job, making as much money as you did before, and you're not working that job anymore, then you've probably got a decent claim to get more money.
Wow. And once again, Kentucky's system, although complicated, is actually really beneficial for those injured workers out there.
It can be. It can be. I don't think anybody is happy with what they get from workers' comp, and it can't replace the injuries they've gone through. But the benefits in Kentucky are better than they are in other states. And again, this reopening seems to be something that everybody forgets about. And I feel like I need to shout it from the rooftops that if something's changed as far as the impairment rating or your job, you need to talk to another attorney because there may be something out there for you.
That makes sense. Well, Scott, once again, as we begin to close up the episode here, what is the phone number that someone could use to pick up the phone and say, hey, you know what, maybe I need to talk to you about possibly reopening my claim?
Again, it's 502-937-5287, 502-937-5287.
And, Scott, you're fairly easy to find. You're right on Dixie Highway, correct?
I'm in the southwest part of town on Dixie, and we occasionally meet people on the east end part off Hurstbourne at some offices there, too. And we will try to make it as easy as possible for you to find us.
Absolutely. Well, Scott, again, I know you're busy. I really appreciate you coming in and sharing this information. There's some stuff that I learn every time you come in and sit down with me, and especially when you're talking about, well, if the plant closes down, that may be an eligibility for reopening your case, which means potentially more money in your pocket just simply because of the injury you originally sustained. I never connected those dots, and today you said, yeah, it's one of the factors.
It's one of the factors.
Outstanding. Scott, I wish you the best, and we'll talk to you here in a couple of weeks.
Thank you.
Take care.
Good
Bye-bye.
talking to you, Jim.
Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's SCHEYNOST law.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.